nonviolent tool we have to create a more perfect union. To me and to millions of others, he's a hero, and I thank him for being here today. In 2006, Republicans and Democrats in the Senate and the House of Representatives joined together to pass a reauthorization of the landmark Voting Rights Act with overwhelming bipartisan support. We're able to do it. One of the reasons we're able to do it is a courageous chairman of the House Judiciary Committee, Congressman Sensenbrenner, true leader in that effort. In fact, having been here at that time as a member, the ranking member of this committee, and watching what went on, I can say that we would not have been able to reauthorize that without his leadership in the House Judiciary Committee. I was proud to work with him back then. I thank him for coming here to testify today, and I think he and I and Congressman Lewis were very happy when we saw the president sign that in the Rose Garden on a gorgeous day, I might add. In Shelby County versus Holder, 5 justices of the Supreme Court held the coverage formula of the Voting Rights Act was outdated. But even the 5 justices who struck down the coverage formula in Section 4 have acknowledged that discrimination in voting continues to be a problem. Chief Justice Roberts said, voting discrimination still exists. No one doubts that. That's why we're here today. Supreme Court has called on Congress to come together to update the Voting Rights Act. Well, we have to work together, not as Democrats or Republicans, but as Americans. People die in other parts of the world trying to obtain the right to have a free country with a free right to vote. Americans should not be denied it by just the application of local laws. We need a strong Voting Rights Act. Dr. King proclaimed, when the architects of our republic wrote the magnificent words of the Constitution and Declaration of Independence, they were signing a promissory note to which every American was to fall heir. But we owe it to our children, and I might say in a very personal way, our grandchildren, to restore the Voting Rights Act to fulfill this promise and uphold the Constitution. No one's right to vote in any part of this great nation should be suppressed or denied. But yet we continue to see that discriminatory practice today. Every one of us, I don't care what our political lines are, we should be totally opposed to suppressing votes. So let's work together on that. Senator Grassley, can we hear from you? And I know that Congressman Lewis has a flight, so after you finish, I'm going to turn to him.
Okay. It's very right for you to hold this hearing, Mr. Chairman, after a significant decision by the Supreme Court and the extent to which Congress has a duty to do it in our checks and balances of government. The Voting Rights Act guarantees the fundamental right to vote for all qualified voters, regardless of race or language. The right to vote guarantees the protection of other rights. The law was necessary to address a shameful history. I have voted to reauthorize the Act. I appreciate the testimony of our congressional colleagues, and I welcome both of them here and point out specifically for Representative Lewis, your participation in the Bloody Sunday helped lead to enacting the law and creating your enduring place in history. Thank you for being here today. We should be pleased that our country has made advances in race relations since the Voting Rights Act was passed. The Act contributed to the progress. No doubt, though, more progress must be made and should be made. And a hearing such as this will help that dialogue to continue. We last voted to reauthorize in 2006. Much has changed since then. The voter turnout rate was higher last year among registered African American voters than for other classes of people. More African American and Hispanic candidates than ever are winning elections. Now, I say that because the Supreme Court has found these facts to be of constitutional significance. We're here today largely because Congress failed to heed the Supreme Court's 2009 warning that the differing treatments of states in the pre-clearance coverage formula raise serious constitutional questions. 8 justices said so. The 9th would have struck the law down at that time. Congress could have drafted a new coverage formula to address those concerns. We could have created a formula based on 21st century realities, not the dramatically different conditions that existed in the 60s and 70s. The court then ruled as it did. Many people believe that Section 2 is the heart of the Voting Rights Act. Unlike Section 5, it prohibits voter discrimination nationwide. Unlike Section 5, Section 2 can be used to challenge procedures before they take effect through injunctions. Over the years, the pre-clearance process has led to many fewer objections to proposed election law changes. Since the last reauthorization, only 31 objections have been made. There have been no objections raised to any changes in 7 of the 16 states that are covered in whole or in part, and in 3 of the states that are fully covered. 99.86% of submissions have been approved. Additionally, the racial gap in voter registration and turnout is now lower in the states that were originally covered in Section 5 than is the case nationwide. The court has given Congress the opportunity to draft a new constitutional coverage formula. I disagree with a member of this committee across the aisle who said, quote, as long as Republicans have a majority in the House and Democrats don't have 60 votes in the Senate, there will be no preclearance. Cynicism and defeatism have never before characterized reauthorization of the Voting Rights Act. Rather than blaming Republicans for blocking a bill that does not exist, the majority should bring forth a proposal for updating the coverage formula in a constitutional way. We should cover the whole country. We could identify jurisdictions engaging in discrimination in the 21st century and where Section 2 is inadequate. There may be other options. I look forward to seeing what is brought before the committee. I certainly understand why there is no proposal yet, but for any new bill to pass, we must respect the Constitution's pronouncements. The court based its ruling in part on the 10th Amendment. Specifically, the court said, quote, the Constitution provides that all powers not specifically granted to the federal government are reserved to the states or citizens thereof, end of quote, and I would point out the word specifically. This is a formulation of the 10th Amendment I've never seen before. It means that Congress can only enact laws that fall within the power the Constitution specifically gives it, such as the enumerated powers of Article 1 and the 15th Amendment, which is the constitutional basis for the Voting Rights Act. The Supreme Court's ruling requires Congress to show greater respect for the limitations of its power as against state authority. It is language that must be kept in mind if Congress considers legislation amending the Voting Rights Act. And the court last month also ruled under the Constitution's election clause, Congress may regulate, quote, how federal elections are held, but not who may vote in them, end of quote. Those decisions are left to the states. Further, any legislative fix should not threaten common sense measures to ensure the integrity of voting, such as constitutional voter identification laws. Overwhelming majorities support these requirements. They know that the right to vote is denied as completely when a valid vote is canceled by the vote of someone ineligible to vote as when an eligible voter is blocked. And the Supreme Court has just ruled that, quote, it would raise serious constitutional doubts if a federal statute precluded a state from obtaining the information necessary to enforce its voter qualifications, end of quote. This hearing is very important, and I commend you, Mr. Chairman, for holding it as soon as you are after the Shelby hearing. I welcome all the witnesses. Thank you.
Well, thank you. We'll start, as I said, with John Lewis. I'm also, in a personal point, I still remember with great fondness your introduction of me when I received the Civil Rights Award, the Humphrey Award. I felt it was one of the culminations of my career in the Senate to be introduced by you. And we've seen, especially recently, so many times on television, some of the scenes of 50 years ago, so I'm glad you're here. Congressman Lewis, please go ahead, sir.
Thank you, Mr. Chairman. I want to thank you, Mr. Ranking Member, and members of the committee for holding this important hearing and inviting me to testify today. Mr. Chairman, I ask unanimous consent that my full statement be included in the record. Since first being elected to Congress, Congressman Sensenbrenner has been a tireless champion of the Voting Rights Act. I'm very proud and pleased to be with him today, my friend, my brother. I've said it before, and I say it again to you today, that Section 4 and 5 are the heart and soul of the Voting Rights Act. The day of the Supreme Court decision broke my heart. It made me want to cry. I felt like saying, come and walk in the shoes of people who tried to register, tried to vote, but did not live to see the passage of the Voting Rights Act. I know that each of you knows this history, but I think it's important for the record to note what life was like before the Voting Rights Act of 1965. When I first came to Washington, D.C. in 1961, the same year that President Barack Obama was born, blacks and whites could not sit beside each other on a bus traveling through Virginia, through North Carolina, through Georgia, Alabama, Mississippi, into New Orleans. We saw signs that said white only, colored only. In many parts of this country, people were denied the right to register to vote simply because of the color of their skin. They were harassed, intimidated, and fired from their jobs and forced off of farms and plantations. Those who tried to assist were beaten, arrested, jailed, or even murdered. Before the Voting Rights Act, people stood in unmovable lines. On occasion, a person of color would be asked to count the number of bubbles in a bar of soap or the number of jelly beans in a jar. In 1964, the state of Mississippi had a black voting age population of more than 450,000, but only about 16,000 were registered to vote. One county in my native state of Alabama, Lowndes County, was 80% African American, but not a single one was able to register to vote. Not one. Selma is located in Dallas County, Alabama. During this period, only 2% of African Americans were registered to vote in this county. And you could only attempt to register on the first and third Mondays of each month. Occasionally, people had to pass a so-called literacy test. Before the Voting Rights Act, 3 young men I knew, James Shaney, Andy Goodman, and Micah Scherner, was working to register African American to vote in Mississippi in 1964. They were arrested, released from jail, to members of the Klan in the middle of the night. Then they were beaten, shot, and killed. On March 7, 1965, Jose Williams, a staff person of Dr. Martin Luther King Jr., and I attempted to lead a peaceful, nonviolent march from Selma to Montgomery. As we marched for the right to vote, more than 500 men, women, and children were chased, beaten, bloody, and trampled by state troopers, some riding horseback. That terrible day became known as Bloody Sunday. A little over a week later, President Lyndon Johnson came before a joint session of the Congress, and he spoke to the nation. He said, "I speak tonight for the dignity of man and for the destiny of democracy." And he presented the Voting Rights Act to Congress. After months of hard work, Congress passed the bill, and on August 6, 1965, President Lyndon Johnson signed the Voting Rights Act into law and gave me one of the pens he used to sign that bill. I remember this period and these struggles like it was just only yesterday. To this day, I truly believe that we are a better country, a better people because of the Voting Rights Act. We have made progress. We have come a great distance. But the deliberate systematic attempt to make it harder and more difficult for many people to participate in the democratic process still exists to this very day. Only hours after the decision was announced by the Supreme Court, before the ink was even dry, states began to put into force efforts to suppress people's voting rights. As I said, and Mr. Chairman, as you have quoted, in a democracy such as ours, the vote is precious. It is almost sacred. It is the most powerful nonviolent tool we have. It is my belief that the Voting Rights Act is needed now more than ever before. A bipartisan Congress and Republican presidents worked to reauthorize this law 4 times. The burden cannot be on those citizens whose rights were or will be violated. It is a duty and the responsibility of Congress to restore the life and soul of the Voting Rights Act. And we must do it, and we must do it now. We must act, and we must act now. We must do it on our watch at this time. Again, thank you, Mr. Chairman, Mr. Ranking Member, and members of this committee for the opportunity to testify today. Thank you so much.
Thank you, Congressman, and you bring us a sense of history. I also thank you for the book that you signed to me in March, Book 1, that you helped write and edit. It will be seen by all 5 of my grandchildren. I mentioned earlier that Congressman Sensenbrenner is a dear friend. We've been friends for years, and he's a civil rights icon in his own right. When he's chairman of the House Judiciary Committee in 2006, he introduced the reauthorization of the Voting Rights Act in the House of Representatives. He worked tirelessly to build a strong legislative record, indicating the need for reauthorization of Section 5. I know, I watched some of those hearings, as he knows, came by, and we discussed it many, many times. But his steadfast leadership, his commitment to protecting civil rights for all Americans, ensured the bill would become law. I think as someone from the other body, I can say, and I was in the minority at the time, and you, of course, were in the majority in your party, I can honestly say that we would not have gotten through had it not been for the work you put in the House. So I will continue to work with him and to make this keep this a bipartisan. It should be a nonpartisan effort. It's one of the few things that definitely should. So, Congressman Sensenbrenner, please go ahead, sir.
Thank you very much, Mr. Chairman, Ranking Member Grassley, distinguished members of the committee. Let me express my appreciation not only for your statement and Senator Grassley's statement, but also the statements that have been made by my colleague in the House, John Lewis of Georgia. I'm not a civil rights icon. I try to be a mechanic to put together legislation that will work. I thought we did it in 2006. We're going to have to repair a few parts this year. And I'm certainly on board to try to put something that will last for a long period of time. I also deeply appreciate the comments that Mr. Lewis has made, because he is truly a civil rights icon for what he did to emphasize the need for voting rights in the Voting Rights Act that Congress successfully passed in 1965 and has reauthorized since. In 2006, I was proud to have served as chairman of the House Judiciary Committee when the Voting Rights Act was last reauthorized, including the coverage formula of Section 5. I thank you for the invitation to participate in this hearing and to provide my perspective on the continued importance of the Voting Rights Act. In 1965, the Voting Rights Act was signed into law. The law was passed at the height of America's civil rights movement, when citizens of part of the country were fighting each other and sometimes authorities over how skin color impacts upon a person's place in democracy. Historic in nature, the Voting Rights Act sought to end decades of racial discrimination that prevented minorities from fully exercising their constitutional right to vote. The law ensured that state and local governments do not pass laws or policies that deny American citizens the equal right to vote based on race. As the leading democracy in the world, the United States should work to keep voting free, fair, and accessible. And that's why the Voting Rights Act is so important. It makes sure that every citizen, regardless of our race, has an equal opportunity to have a say and to participate in our great democracy. In 1982, I was pleased to help lead negotiations to reauthorize the Voting Rights Act then. The legislation cleared the House by a vote of 389 to 24 and was signed into law by President Reagan. When signing the reauthorization, President Reagan stated, quote, "There are differences over how to attain the equality we seek for all our people. And sometimes amidst all the overblown rhetoric, the differences tend to seem bigger than they are. But actions speak louder than words. This legislation proves our unbending commitment to voting rights. It also proves that differences can be settled in a spirit of goodwill and good faith. As I said before, the right to vote is the crown jewel of American liberties, and we will not see its luster diminished," unquote, President Reagan. One of my most cherished keepsakes is one of the pens that President Ronald Reagan used to sign the 1982 extension. Anyone visiting my office will notice that this pen is proudly displayed. A duty to support the Constitution once again led me to shepherd the 2006 reauthorization of the Voting Rights Act. While I was chairman of the House Judiciary Committee, we held dozens of hearings examining the effectiveness of the Voting Rights Act, whether the VRA should be extended, and if so, what the extension should encompass. The committee assembled more than 12,000 pages of testimony, documentary evidence, and appendices during its exhaustive consideration. In fact, the legislative record accompanying the consideration of the Voting Rights Act extension in 2006 is among the most extensive in congressional history. The committee's bipartisan conclusion, while we have made dramatic progress in ensuring no American is denied his or her right to vote based upon the color of his or her skin, the work remains incomplete. Again, in a bipartisan fashion, the House passed a 25-year extension. As we are here today because of the Supreme Court's ruling in Shelby County versus Holder, which severely weakens the election protections that both Republicans and Democrats have fought so hard to maintain over the years, the Court essentially disregarded years and years of the extensive work of the legislative branch and substituted their own judgment. In a narrow 5-4 decision, the justices voted to eliminate the law's existing formula for selecting which places are allowed to make changes to their election laws or procedure without clearance from the U.S. Department of Justice. Although the court left in place Section 5, a provision that requires states or parts of states to ask permission from the federal government before making changes to their elections, that part of the law has little or no effect without the formula in Section 4, which was struck down. By striking down Section 4 of the 1965 Voting Rights Act and thereby gutting the Act's Section 5, Congress is now presented with a challenge and a historic opportunity. We are again called together to restore the critical protections of the Act by designing a new formula that will cover jurisdictions with recent and egregious voting records. Our sacred Constitution guarantees that an American citizen cannot be kept from exercising his or her God-given right to vote because of race or color. Though the Voting Rights Act has been enormously successful, we know our work is not yet complete, and 8 years ago had 12,000 pages of a record to prove it. Discrimination in the electoral process continues to exist, and threatens to undermine the progress that has been made over the last 50 years. I am committed to working to pass a constitutional response to the Shelby County versus Holder decision. And I look forward to working with anybody who wants to approach this effort in good faith. I believe that the Voting Rights Act is the most successful of all of our important civil rights acts that have been passed since the mid-1950s in actually eliminating discrimination. We cannot afford to lose it now, and it is our obligation as senators and representatives to continue it. Thank you.
Well, gentlemen, I thank you both very, very much. And I wanted to hold this hearing before the August break because I want to be able to use the August break to work the phones a lot and talk to a lot of people from Vermont, people around the country, but be able to use that as a base to do it. And I'm hoping that the two of you and anybody else in the House who may want can join with those of us here in the Senate who want, and we come back in the fall and see what we can do. I know you both have a tight schedule. You're welcome to stay and watch if you like, but I'd be happy to have the next panel come up if you want to leave.
Yeah, we're due for votes pretty soon in the House.
I better let you go. It's a long way over there.
Sometimes the differences between the House and the Senate are the difference between here and the moon. Hopefully not on this one.
I hope not in this. And as you know, my office, I have an office that is just a couple of feet from the so-called dividing line between the House and the Senate. And I like the fact that we're able to walk back and forth across that line often, as the three of us have done in many different issues. And I hope that both bodies will on this issue, because if you protect the right to vote for everybody, it's one of the greatest steps you can take to protect a democracy. So I thank you both very, very much for being here. Thank you. And I know as we're going to set up for the next panel, Senator Durbin, who's the chair of the Civil Rights Subcommittee, has held hearings on this. Senator, before we start that, did you wish to say something?
Mr. Chairman, I want to thank you and Senator Grassley for this hearing today, and I want to congratulate my friend, Congressman John Lewis, for coming over and producing testimony that no one else can produce because of his singular role in the history of civil rights in America. And a special thanks to Congressman Jim Sensenbrenner, who shows that there's true bipartisanship alive and well when it comes to preserving civil rights. Congressman Sensenbrenner, thank you for being here. Mr. Chairman, it was 7 years ago that 98 senators and 390 House members reauthorized the Voting Rights Act by an overwhelming bipartisan vote. After 21 hearings and 90 witnesses testified, a 15,000-page record was produced. Congress passed the bill. President George W. Bush signed the reauthorization. We did so because we all recognize that despite real progress in America, unlawful and unfair discrimination in voting remained. I heard some of those discriminatory practices firsthand in the series of hearings in my Constitution Subcommittee last Congress. Here on the Hill, I chaired the first congressional hearing to examine new state voting laws that limited early voting, tightened registration requirements, and required photo IDs. We then took the subcommittee on the road. At the invitation of Senator Bill Nelson, we went to Tampa, Florida. And at the invitation of Senator Sherrod Brown, we went to Cleveland, Ohio. In those places, we invited election officials from both political parties to testify as to the changes in state law that were being contemplated and implemented in those two states of Florida and Texas. Mr. Chairman, before there was any testimony taken at great length, we asked the election officials a basic question. What were the instances of voter fraud in your states of Florida and Ohio that led for the states to change the laws relating to how people would register to vote and when they could vote and how they can vote. In both states, testimony was the same from election officials of both political parties. There was no evidence of voter fraud. None. These changes took place in the context of reducing opportunity for people to vote, period. I'm not going to defend one person who tries to vote illegally or fraudulently. None of us would. But in those two states, from election officials of both parties, there was no basis for these new state laws. When the time came to challenge these laws in federal court, what statute did they turn to? The Voting Rights Act. The Voting Rights Act asks the very basic question that goes back to the 15th Amendment as to whether we're keeping our promise to make voting racially free and free for all Americans. And that is why this hearing is so important and this testimony is so important. I'm just going to give three quick examples, Mr. Chairman, and yield. Do we still need this? Is this something that belongs in a museum, this Voting Rights Act, in the Civil Rights Museum somewhere? We still need it. Listen to what we faced recently. In 2001, in the city of Kilmichael, Mississippi, an election was canceled because an unprecedented number of African American candidates decided to run for office. After the Department of Justice used the Voting Rights Act to require the election move forward, the town elected its first black mayor and its first majority black city council. 2001, Kilmichael, Mississippi. In 2004, officials in Walker County, Texas, threatened to prosecute 2 black students after they announced their candidacy for county office. When that threat didn't keep them off the ballot, county officials tried to limit African American turnout by reducing early voting, but only at polling places near a historically black college with a large number of black voters. 2004, Walker County, Texas. In 2012, after the 2010 census showed that African American voting population had grown significantly in the consolidated municipal government of Augusta, Richmond, Georgia, the Georgia legislature passed a bill to change the date of municipal elections, but only in Augusta, Richmond, Georgia County. The bill would have changed the election date from November, when African American turnout was known to be high, to July, when it was substantially lower. 2012, the state of Georgia. Do we still need the Voting Rights Act? Yes, we do. That's why this hearing is so important. Mr. Chairman, I'm glad that you brought those 2 opening witnesses, and I'm glad that the panel will follow and we'll have a chance to raise these questions. And I think you're right to make this issue an issue to be considered by the full committee rather than just our subcommittee. And I thank you for this opportunity.
I can assure you your subcommittee is going to have a great deal of work to do on this, as you already have. Our first witness is Ms. Luz Weinberg. Did I pronounce your first name correctly? Luz Weinberg. I apologize. She served as City Commissioner of Ventura, Florida since 2005. I understand you're the youngest person, first person of Hispanic descent to hold that office. Also the Vice President of the Board of Directors for NALEO, the National Association of Latino Elected Appointed Officials. Ms. Weinberg, please go ahead.
Thank you, Mr. Chairman, Ranking Member Grassley, and members of the committee. Thank you for the opportunity.
Your microphone's on. There's a little button on the front there that says talk.
Thank you. Give me those 10 seconds back. Chairman Leahy, Ranking Member Grassley, and members of the committee, thank you so much for the opportunity and the invitation to submit my testimony here on the need to restore the protections of the Voting Rights Act. Mr. Chairman, as you mentioned, I am a Republican elected to serve on my city of Aventura as a nonpartisan in the city of Aventura in Northeast Miami-Dade County, Florida. I am the first, indeed, and still the only Hispanic to hold that office. I have taken also statewide and national leadership positions. Just recently, Governor Rick Scott appointed me to serve on the Miami-Dade County Expressway Authority, and I also serve as the Vice President of the National Association of Latino Elected Officials. And thank you, Senator Durbin, for joining us last month. I'm here today to share with you my firsthand account of the critical impact of the Voting Rights Act in guaranteeing access to the ballot box. As a result of the recent Supreme Court case, I urge this committee to once again demonstrate your clear and principled commitment to equal voting rights for all Americans, regardless of race, language spoken, and to also act act swiftly to restore the protections. Whether to maintain Voting Rights Act, it's not a partisan issue. It's a nonpartisan issue. It's an issue for all Americans. Whether Republicans or Democrats, all Americans strongly believe in fair and equal electoral opportunities. My experience serving as an elected official in South Florida has afforded me the privilege of being personally acquainted with how, absent a proactive impartial check, election policies may disenfranchise ethnic and language minority communities. Ever since I moved to Florida from Puerto Rico in '86, I've had a front row seat to observe how the unfortunate repeated attempts to adopt and implement policies that continue our national history of putting racial, ethnic, and language minority voters at a disadvantage. Two main incidents come to mind. Number one, Osceola County in Central Florida is one of many counties that have maintained an at-large election system for its commissioners. Only when its voters elected to switch to single-member districts was the first Hispanic commissioner finally elected. In reviewing the county's election law changes, the Department of Justice identified that the commissioners favored a return to at-large elections, in part because they recognized that the substantial growth of the county's Latino population would lead to Latino voters electing candidates of their choice. Since 2002, Osceola County has twice more faced charges that its electoral methods would reduce or eliminate Latino voting rights. Secondly, in Florida, Latinos are more likely than average to have become registered to vote through third-party registers. Third-party registers, however, became subject to strict reporting requirements, deadlines to return registration forms, and large fines in 2011. These requirements were later withdrawn, but the change in the law led to several organizations like the Women League of Voters suspending their voter registration operations in Florida, which of course then meant a drop that we saw of 39% of registration. In the 1975 expansion of the VRA, 5 Florida counties were singled out for electoral discrimination against Latino voters and low participation rates that made them subject to the preclearance process set forth in Section 5. The VRA protects not just Latinos in these 5 counties, formerly subject to preclearance, but it protected all voters statewide. For example, through the 1980s and 1990s, preclearance was actively used in Florida to ensure that absentee balloting procedures did not put underrepresented voters at a disadvantage. More recently, the preclearance process forced the careful reconsideration of the disproportionate impact that Latino voters might experience because of decisions to reduce our state's early voting period and to scrutinize the citizenship of Floridians already registered to vote. The successful application of Section 5 has occurred not only in Florida in the course of formal requests of preclearance. The very fact that these state policymakers have had to anticipate fulfilling preclearance requirements has influenced them to voluntarily reconsider and reshape proposed new election laws. For us Floridians, and particularly for Latino voters in Florida, the preclearance process of the Voting Rights Act has not only been effective, but also critical in ensuring the preservation of equal electoral opportunities. The preclearance mechanism has no peer. It is uniquely tailored to prevent irreparable harm to voters and candidates by requiring review for discriminatory effect before a new law may be implemented. It is, by its very design and definition, still very much necessary in our 21st century America. On a personal note, I arrived in this country as a native-born immigrant. That is to say, I am one of millions of Puerto Ricans who leave the island for the mainland for a better life. I registered to vote as a young adult who had just a couple of years before my arrival not spoken a word of English. I have 3 children. I was very proud when my oldest son, Jonathan, now 20, registered to vote and voted for the first time 2 years ago. Last year, my daughter, Jessica, turned 18. Just 2 weeks after the election cycle, she missed it, but she was filed and ready to register and ready to vote. Jonathan registered a Democrat. Jessica registered an independent. Their elected official mother, myself, is a Republican. So in my household, we are Latinos, white Latinos, we're Afro-Latinos, we speak English, we speak Spanish, we speak sometimes Spanglish, and sometimes very badly. But first and foremost, we're Americans in my household, and we take our electoral process, our exercising our right to vote, our ensuring that the Voting Rights Act are preserved. We see it as a nonpartisan, non-racial, and non-language dependent priority. And I urge you to once again demonstrate your commitment to this priority of equal voting rights for all Americans, and to please act swiftly to restore these protections so very necessary through the Voting Rights Act. Thank you.
Thank you very much. The next witness is Mr. Michael Carvin, a partner at the law firm Jones Day here in Washington, D.C., where he focuses on constitutional appellate litigation. He has testified before this committee a number of times at the invitation of my Republican colleagues, and welcome again, Mr. Carvin.
Thank you, Mr. Chairman. Senator Grassley. Obviously, the committee is facing a very serious question, as is the entire Congress. Does Shelby County's invalidation of Section 5 create some kind of gap in the civil rights laws which might expose minority voters to unconstitutional discrimination? The thrust of my comments today is that there is no gap because Section 5 is no longer needed to ensure equal opportunity for minority voters for one simple reason, which is you have Section 2 of the Voting Rights Act, which has always been viewed as the heart of the Voting Rights Act. Section 2 is a very muscular provision which was amended by this body in 1982 to prophylactically eliminate anything that could be characterized as purposeful discrimination because it prohibits anything with a discriminatory result for minority voters. It was ballyhooed then and was universally hailed as a very extraordinarily successful piece of legislation that has done much more than Section 5 to eliminate unconstitutional voting discrimination. Section 5, on the other hand, was limited. It was limited in terms of the kinds of voting practices it got at, only changes, in terms of the states it was addressing, and in terms of time. It was always a temporary supplement to Section 2. So I think the question that the Congress has to grapple with is not whether discrimination persists in the jurisdictions covered by Section 5, but whether it's the kind of discrimination that can't be effectively remedied by Section 2 of the Voting Rights Act. And I'd submit that there's not much argument that Section 2 is inadequate to the task. A couple of logical, intuitive points. We don't have pre-clearance requirements. It doesn't seem to be necessary for two reasons. One is we don't have it in most states. We don't have Section 5 on top of Section 2 in most states with respect to voting discrimination. And we don't have any kind of analogous pre-clearance requirement for any other form of discrimination. Employment, housing, educational discrimination is all dealt with through statutes like Section 2 that prohibit certain actions, not supplemented in any way by a pre-clearance requirement, even though, for example, employment discrimination is much more difficult to prove than voting discrimination because it's done in private without the kind of ready access you have in the voting context. And I think that Congress actually, with respect to what we've been calling first-generation ballot access issues, I think that was the finding of Congress in 2006, that those problems had been addressed as well in the covered jurisdictions and in the non-covered jurisdictions, so there was really no reason to extend Section 5 just to get at those ballot access issues. And there was no argument, even though Section 2 was more than adequate in Oklahoma and Arkansas to eliminate their kind of voting discrimination. No one in Congress in 2006 found that what was okay in Arkansas was inadequate in Brooklyn or Manhattan or Mississippi, in part because Congress found that Mississippi actually had the highest participation of black voters of any states, but nonetheless remained a covered jurisdiction. In terms of second-generation issues, and that was the principal focus of the Congress in 2006. They said, look, the covered jurisdictions have done a terrific job, indeed a better job than the non-covered jurisdictions in fostering minority participation and turnout. But they are diluting the vote through these at-large electoral systems and racial gerrymandering. And I'd like to make 2 points about that. Section 2 is actually more effective at dealing with second-generation vote dilution issues than is Section 5. For one thing, Section 5 can't attack at-large voting systems because it only is triggered if there's a voting change. So if an at-large election system is in place, it can't be got at by Section 5, but it can be got at by Section 2. There's been an argument made which in my view is completely false and counterfactual, which is somehow Section 2 challenges to racial gerrymandering are too slow or not effective enough. That's completely untrue. In every state outside of Section 5, people don't sit around before they bring their Section 2 lawsuits and say, let's have 2 or 3 elections and see how things go. They do exactly what they do in the Section 5 jurisdictions. They go to court before the new redistricting plan is entered and seek an injunction. The highly publicized case in Texas makes this point extraordinarily well. The Section 2 court had done its vote dilution work in November of 2011, well before the elections in 2012, while the Section 5 court never issued a decision until late August in 2012. So the point is that Section 2 courts can act and do act just as speedily and just as effectively in dealing with these redistricting issues. The only thing that the demise of Section 5 will help eliminate is the compelled racial gerrymandering that the Justice Department imposed on a number of jurisdictions to create these districts that were struck down as unconstitutional in Shaw and to be used as they were in Texas to protect white Democrats, even though there was no cognizable or large minority population in those districts, and frankly, to end the partisan uses by the Republicans of the Voting Rights Act. Some of the strongest supporters of the Voting Rights Act have always been Republicans because it's politically advantageous for Republicans to have these majority-minority districts because the adjacent districts present political opportunities. Thank you, Mr. Chairman.
Thank you very much. And our next witness is Justin Levitt, Associate Professor of Law at Loyola Law School in Los Angeles, a national expert in constitutional law and voting rights. Before he joined the faculty of Loyola, he was counsel at the Brennan Center for Justice at New York University School of Law. He worked on cases promoting equal access to voting. And again, I should note that all of you, your statement or any addition to it will be put in the record. Professor Levitt, I don't want you to think it's because of anything you have said or about to say that I leave and turn the gavel over to Senator Whitehouse. But I'm also required back on the floor. And so, but please go ahead, sir.
Not at all, Mr. Chairman, and thank you very much. Mr. Chairman, distinguished members of the committee, thank you for the invitation to testify here as well. Our Constitution expressly gives Congress the specific enumerated power and the obligation to ensure that there is no electoral discrimination anywhere in the country based on race or ethnicity. Congress has repeatedly attempted to step up to that responsibility, not perfectly perhaps, but pragmatically. Shelby County ripped a sizable hole in Congress's work. That decision has left Americans today less sure that discrimination won't taint their elections. We have to correct that damage. Sweeping national statistics hide the fact that, unfortunately, there are still public officials who try to limit electoral opportunity based on race or ethnicity, sometimes because of contempt, sometimes because of perceived political advantage. It's disgusting and it's illegal. And even with armies of lawyers, it's very hard to fix using existing tools like Section 2. Now, normally, we in the legal system depend on responsive lawsuits, the sort of tools that Mr. Carvin was talking about. If there's a legal problem, you sue, you prove harm, and it gets fixed. That's the way that the employment system, the housing system, the education system works. Exactly as Mr. Carvin said, voting and election laws are different. These normal lawsuits attack one practice at a time. Officials looking to limit political power based on race just switch tactics. Rule X draws a lawsuit, okay, shift to Y. That draws a suit, okay, shift to Z. And important here, the official doesn't bear the costs of this whack-a-mole game. The taxpayers do. And if taxpayers get sick of it, it's hard for them to toss him out of office because the tactics he's changing affect the very structure of how the elections work. Election laws are different. Normal lawsuits are also a little bit like ocean liners. They're complicated, they're very expensive, they're slow to get going. They can take years. And frankly, I'm not sure which Texas case Mr. Carvin's talking about. The court in Texas still hasn't delivered a decision on the merits, years after the original districts were put in place. There's still no decision based on these normal lawsuits. In the meantime, when normal lawsuits are taking all of this time to get up and going, elections infected with discrimination are taking place. We know that elections have consequences. Well, discriminatory elections have consequences too. Even when the contest is unjust, the winners still become incumbents and they end up making policy in the meantime. While we're waiting to get the election structure right, It doesn't fix the policy that's already been passed. Election laws are different. These aren't just theories. The 2006 Congress collected 15,000 pages of examples. I've got plenty more from not just before 2006, but 06, 08, 2010, 2011, ongoing. They include some prominent statewide problems, but I'm even more concerned about local jurisdictions, where those most at risk have the least resources to fight back. These examples also just aren't old news. In 2009, 2 months after the president's inauguration, Chief Justice Roberts, Justice Kennedy, and Justice Alito said, and I quote, "Racial discrimination and racially polarized voting are not ancient history. Much remains to be done to ensure that citizens of all races have equal opportunity to share and participate in our democratic processes and traditions." Congress has understood that much remains to be done. Repeatedly, it's recognized that the existing toolkit of tools like Section 2 are powerful, but for the most pernicious electoral discrimination, they are also, and here I quote again, inadequate. In 2006, Congress stepped up to meet the continuing need, which brings us to Shelby County. The Supreme Court's ruling had an enormous impact, but it also leaves Congress with plenty to do. The court said that the formula Congress used in 2006 to cover some states and not others for preclearance purposes wasn't sufficiently tied to current conditions. It did not rule out a different formula. It did not rule out the idea of preclearance at all. It did not rule out safeguards other than preclearance, above and beyond the normal responsive litigation toolkit that exists today. It did not say we fixed the problem of discrimination in voting. And it did not change the basic truth that, quoting Chief Justice Roberts, the 15th Amendment empowers Congress, not the court, to determine in the first instance what legislation is needed to enforce it. So now it's up to Congress once again. Polls show that the American people understand that this extraordinary right still needs more than just ordinary protection, whatever that may look like. In the last 50 years, Republicans and Democrats in overwhelming bipartisan majorities, including every member of this committee who was able to cast a congressional vote in 2006, have stepped up to offer on a bipartisan basis that extra protection these very special rights demand. And I'm delighted to offer whatever assistance I can as both houses of Congress resume their bipartisan task. Thank you very much.
Thank you very much, Professor Levitt. We will begin the questioning with Senator Durbin.
Thanks. Professor Levitt, when I read this decision in Shelby County and noted the logic and argument used by the Chief Justice, it seemed to suggest that absent Congress showing brand new evidence on a regular basis that we're dealing with some old problem in America that has virtually gone away. That seems to be the majority argument in the case. I think back to the last election cycle. There was an organization known as the American Legislative Exchange Council that was financed by major corporations and major political players that went state by state to change the electoral laws to restrict the right to vote. I visited 2 of those states. The witness, Ms. Weinberg, I was in your state of Florida, and as I mentioned, had electoral officials from both parties who couldn't point to a single instance of voter fraud that led to these changes. It clearly had some other design. Now, many of these changes in state law were challenged under the Voting Rights Act under Section 5. For example, voter ID, as to whether or not it was discriminatory toward minority populations, the disabled or elderly, and the like. So I would just ask you if you are familiar with this background and believe it's evidence that the Voting Rights Act and its protection of that basic right to vote still is a vibrant and timely issue.
Thank you, Senator. I am, and I've had the opportunity to speak with you on your committee about exactly these issues that you've been highlighting. They are of concern, and they are very much present. And they exist not only at the statewide level, but at the county level, at the city level, at the municipal level, all the way down at all levels of government. There are still profound challenges. The existing tools that we have now help. But I do not believe that they are in any way sufficient. I believe that election laws are special and demand more.
I might, Mr. Chairman, ask for unanimous consent or permission to enter into the record an exhibit which demonstrates the financial supporters of the American Legislative Exchange Council. Many corporations, once they learn what the agenda was of this council, have withdrawn their membership and financial support, but many have continued it, and I'd like to put this in the record. Let me add quickly.
Without objection.
It is their right under our Constitution, their right of speech, their right of assembly, whatever they want to exercise, to spend their money for this purpose to try to change laws. I think it's legal and constitutional. But I think everyone should see whether the companies that they're doing business with are, in fact, using their profits to restrict the right to vote through the American Legislative Exchange Council. Mr. Carvin, Professor Carvin, you talked about Section 2 and the fact that it is there as the last bulwark of protection. We shouldn't be so distressed about the court's decision as it related to Section 4. Your argument was considered by Justice Ginsburg in this Shelby County decision, and she noted on page 14, Congress produced evidence that litigation under Section 2 of the VRA was an inadequate substitute for preclearance. In other words, we addressed that directly when we reauthorized the Voting Rights Act. She went on to give two specific areas. Litigation occurs under Section 2 only after the fact, when the illegal voting scheme has already been put in place and individuals have been elected pursuant to it, thereby gaining the advantages of incumbency. An illegal scheme might be in place for several election cycles before a Section 2 plaintiff can gather sufficient evidence to change it. Then she goes on to say, and litigation under Section 2 places a heavy financial burden on minority voters. Congress already also received evidence that preclearance lessened the litigation burden on covered jurisdictions as well, because preclearance process is far less costly than defending against a Section 2 claim. So your argument that Section 2 is a good alternative seems to have been addressed directly by Justice Ginsburg. Would you like to respond?
Sure. It's quite factually inaccurate, the assertion that you wait on Section 2 cases until elections have already occurred to challenge it. Your state is actually a good example of this. There's never been a congressional redistricting in Illinois, which is not a covered jurisdiction, that hasn't been adjudicated prior to the first election, and some have been struck down on Section 2 grounds. The Texas case I was referring to, they entered a admittedly temporary but interim remedial order a year in advance of the elections. Section 5 and Section 2 litigation on redistricting is indistinguishable. You bring in a bunch of experts, you look at prior electoral returns, and you make projections going forward.
Mr. Carvin, it is dramatically different in my state, because when we put a redistricting or reapportionment map together, we know it's going to be challenged. The Democrats and Republicans do that for a living every 10 years. It isn't a question of gathering poor, minority, dispossessed plaintiffs and trying to get the money together as well as the evidence. We're prepared for this. It's a regular ritual in my state and most others.
And most others. Redistricting is not an under-lawyered operation here. The notion that these plans are somehow sneaking through in the dark of night, Justice Ginsburg says you have to wait for 4 electoral cycles.
But that's a lot different than some remote rural jurisdiction that might be faced with this same allegation of discrimination and have to bring together the lawyers, the money, and the evidence to challenge under Section 2.
Your argument then, Senator Durbin, with respect, is not that you have to wait for elections to go by, you have to go find a lawyer. We can both agree that Justice Ginsburg was flat wrong in suggesting you have to wait for elections to go by. As your experience in Illinois shows, the lawyers get together right after the map is passed and run to court. So that's not true. Does it happen less frequently in rural counties? That may be true, but that's the way we enforce every civil rights law from Title VII to Title VIII. And in all of them, if you have a meritorious claim, all of your expenses are paid for by the other side under the fee-shifting provision. We have political parties that are directly involved in redistricting. There's not a civil rights group in the country that doesn't have a voting system.
I think
of course, we've now got a lot of lawyers.
Major point on redistricting, and I've responded. Professor Levitt, I'll close by allowing you a chance to respond.
Yeah, it's odd to hear Mr. Carvin, who's a practitioner, step into the realm that I normally find myself in, which is pure theory. And I'll say that I have also been an election practitioner, and I can tell you that the facts on the ground look different. Ask Charleston County, ask the voters of Charleston County, South Carolina, whether a case was brought that they were able to get relief for before the election happened, and they will tell you, no. Case was brought in 2001. Plaintiffs asked for preliminary relief. They were denied. Elections happened. Elections happened again. It wasn't until 2004 that the court was able to actually provide relief. The existing responsive litigation system that we have is not only slow, it's expensive. And I'm delighted that Mr. Carvin's going to front the money for civil rights lawsuits all over the country. There are lawsuits that I would love to bring now, but I'm not independently wealthy and can't wait the 4 years to collect fees. There are, in my home jurisdiction, places that desperately need Section 2 lawsuits brought where they're not being brought, in part because the data is hard to get, because the